May it please the court. Michael Sastre on behalf of the petitioner. Your Honor, we have under review today a August 2024 order which effectively denied any right to discover any of the decedent's mental health records whatsoever, and also ordered for those records to be destroyed and stricken from the court file. The reason why we believe this rises and requires certiorari review is espoused in the Gia Colon case from the second DCA and the cases that follow it, other second DCA cases, including the Bush-Ivo case and the Western Beak case. The effect of the court's order was to essentially strike, well, not essentially, in his own words, strike the records which should be discoverable from the court record. That would eliminate any ability for...
Was being struck the SSA documents correct?
Well, I believe there were portions of them that were identified as mental health related. I think Operation PAR, which is some sort of rehab or something.
But as I read the record in the briefs, I come away with the notion that there are other medical records that would have a bearing on matters such as damages and life expectancy.
I believe, yeah, in terms of medical records, but the question is about the discoverability and the admissibility of mental health records, which is clearly...
It's not clear to me what mental health records, if any, are included in other medical records, I guess, are available.
Well, and I guess maybe Your Honor's heading toward a waiver issue, but the other medical records from my review did not address significantly any mental health treatment. So to my knowledge, these are the bulk of any mental health or treatment records. You know, the Russell and the Lowitz case talk about the discoverability of those records in a wrongful death context. And specifically, I know we mentioned life expectancy already, but, you know, Russell gets into the issues of health, a person's habits, and we believe that mental health records in the context of a wrongful death, in the context of a decedent, show or can show or reflect on the relationships of survivors. So it's not simply the life expectancy issue.
Supposed in terms of life expectancy, though.
I'm sorry?
My understanding, as I read the materials, is that, you know, relationship with the survivor was not the point. The point was the ramifications of these alcohol abuse, basically, on his life expectancy.
Well, I think that's what the plaintiff was harping on, life expectancy. We argue it in the sense, and when we talk about Russell, we talk about life expectancy, health, and the person's habits. But to Your Honor's question, how would it affect life expectancy? Well, I think drug addiction or a depression or any manner of...
My understanding on this record was you had the Social Security Administration record that included the Operation PAR materials, which isn't mental health, it's substance abuse, substance dependency.
I
believe that falls psychologically under the DSM.
All I'm saying is that's what it was. It wasn't generally the man was depressed or whatever. He had a dependency, substance abuse dependency.
I can't say that. I don't know
That's what Operation PAR is about. And that we know that from the testimony of Mr. Plaintiff, that was years back. And you know that the decedent had been successfully gone through rehab and been sober for I don't know how many years now, but many years.
I believe the representation is that the records go back 7 years before death, which would be when Miss Rachel Raines, his only daughter, would have been a teenager. So 13, 14.
Don't you have a problem that, you know, and I was kind of surprised you didn't address this in reply. With the federal regulations about disclosing these materials?
In what manner is it the court's belief
they
that...
can't be disclosed and they can't be basically used in any way?
Not even when relevant, not even when subject to court proceedings?
Doesn't have a relevancy exception. And the respondents raised this in their response to your petition for cert, and you didn't address it in reply.
Well, I thought it was fairly clear under both the federal and the state law and the state statutes and the state precedent before this court that that information is discoverable. And it can, therefore, it can be disclosed.
Say no state can override these records. I mean, and of course, we do have the supremacy clause.
I don't read the federal regulations the same way, or the same to limit the discovery. That would probably apply to medical records as well. So, and the request under the state, under the federal law was not made until after they were disclosed. So it's too late at that point. But I mean, I guess if we're saying that medical records or mental health records can never be disclosed in a court case, that's certainly.
That's not, we're talking about substance abuse records.
Okay. I didn't know what they were, which is why they were disclosed under seal. And I think our briefing reflects that. They were looked at, I think, August 8th, and then categorized and then sent to the court. And I believe, by the way, that's still part of the lower court's purview to further rule on any of these issues, which I think you're bringing up, Your Honor.
You have also an issue about, you have to show that your ability to defend the case has been eviscerated.
Well, I think if we don't know the scope of the records, we can't talk to the jury about that. We don't know how the evidence would have impacted them or their decision making. We don't know how.
But does that eviscerate your defense, eviscerate your ability to defend the case?
It significantly impairs it. Yes, I believe it significantly impairs it in accordance with the precedent that's come out of this court in Westerbeek and Jekyllone and so forth. And that's part of it. We don't know what's out there. We don't know what's in the records. We don't know how it might affect a jury's consideration. We don't know how it might affect how a jury views the relationship of the parties or growing up during these teen years, as Your Honor mentioned. And the effect of the court order would be to permanently deprive that right. So there's no way to put the cat back in the bag, as it were. The other thing I wanted to mention is we're talking about the discoverability of this information. We're not talking about the admissibility of it. The court would be the one that would do an in-camera inspection of the records in accordance with the case law. And a thing that I think has maybe, and it is mentioned in the briefs, but it's not really been addressed, is the concept of whether there's been any kind of waiver on these issues. Because in Ms. Rain's first deposition taken before any SSA records were released whatsoever, she mentions the PAR briefly, the PAR treatment briefly on one page of her deposition. The records, or part of the records, have also been filed with this court and with the lower court, and we believe there's been a subject matter waiver of any privilege as well.
As I'm reading the federal law, it doesn't seem to be a waivable privilege. It seems to be a prohibition against any sort of use or disclosure.
So, I'm sorry, and Your Honor hasn't read the records, but apparently you've got some familiarity of what would be in these records, the PAR records?
Well, yeah, I mean, it's all over the briefs that the Social Security Administration records included PAR treatment records.
Sure, but I don't know what's in those.
Notwithstanding the limitation of the order permitting release.
Sure, but we don't know what's in those records, which I think is part of the point. So we also, the issue of any federal law violation or any of those issues is before the lower court. I don't know that it wasn't raised.
any issue of law would also be before this court too, would it not?
This court would,
I
yes.
mean, it was raised in response to your petition.
Well, I thought we had addressed and we had provided our moving papers in our supplemental appendix where we had briefed that in depth. So I apologize that nothing more was added other than the 16-page brief that we provided to the lower court addressing these issues. But again, I don't think that this supplants the entirety of either Florida precedent, case law, or statutory law as it concerns mental health treatment, whether that mental health is in the form of depression, anxiety, or alcohol addiction or otherwise.
Well, here's one quote this from the feds. No state law may either authorize or compel any use or disclosure prohibited by the regulations in this part. All of which is to say, I suppose, that we are charged here not with determining what the trial court erred, trying to determine what the trial court violated the essential requirements of law. And it's hard for me, frankly, to apply the federal regulations to say that the court violated the essential requirements of law. The essential requirements of law suggest otherwise.
Well, I guess your ruling would be overturning the Russell case then from the 5th District, which found that alcohol treatment records are discoverable and are relevant in wrongful death cases.
And the feds don't say you can't discover alcohol treatment records. They say you can't discover treatment records from facilities that are funded by the feds and the records are maintained by the feds. And that's what happened here.
Oh, but I had no idea that PAR was funded by the feds or that, I mean, I think this is beyond what our knowledge was or.
The record is maintained. You didn't get the record, didn't come from PAR. The record came from the Social Security Administration, which are records maintained by the feds. Right? This came up because the Social Security Administration sent you records that it wasn't supposed to, that included the PAR treatment records.
Okay. So, but at the core of this are the mental health records discoverable? Are the PAR treatment records, if they had not been included in the Social Security Administration records, would they not still be?
Did you go to PAR and seek these records?
I'm sorry?
Did you go to PAR and seek these records?
No, the court's order was pretty definitive in terms of mental health discovery. That's why that's where we believe there's a deviation, departure from the essential requirements of law. And when you look at the Russell case and the Loads case and so forth. I guess before disclosing the records to counsel and to the court, we should have researched who PAR was and the possible interplay of these. But we thought we were following appropriate procedure, and I think the lower court has agreed with us thus far as well, that to disclose them under seal and for in-camera review, we believe was a proper procedure to follow in this case.
Professor, you didn't mention what you wanted to reserve your brother. You're closing in on it.
Sure. Let me. I apologize for that. I meant to reserve 4 minutes.
Necessary.
Yeah, 4 minutes. Thank you. And again, to summarize, we think the information that is being sought, mental health information, is discoverable in wrongful death actions. We think it does affect, or can affect anyway, multiple issues in a proceeding. We agree that discovery should be limited and it should be regulated by the trial court, by the trial judges who should conduct in-camera inspection of such records. I believe the order in this case, I know we've been talking about the details of the SSA disclosure to us and the PAR records and how they're to be categorized and whatnot. But at the heart of that order is an absolute denial of any discovery related to mental health records. And that's what we believe the issue is before this court on certiorari review. And I will render the remainder of my time and rest on the briefs. I have 4 minutes in reserve.
Good.
Thank you all.
Please the court. Good morning. Scott Arthur on behalf of the respondent, Julianne Garisto, as personal representative of the estate of Christian Rains. Petitioner cannot satisfy the criteria necessary to invoke this court's certiorari jurisdiction to compel the trial court to conduct an in-camera inspection for a number of reasons, including the petitioner cannot establish irreparable harm. The petitioner failed to comply with the procedural and substantive requirements of controlling federal law, and the records relate to treatment, which was remote in time from the death of Mr. Rains. And as the court points out, there were nearly 2,000 pages of medical records available that were proximate in time to the death for the defense to be able to evaluate Mr. Rains' life expectancy. The burden to show irreparable harm from a trial court's denial of discovery is actually similar to the burden necessary to show good cause to get past the federal presumption against disclosure of these privileged records. Under both standards, there must be a showing that the information of such critical importance to a claim or defense that the defense is essentially incapable of supporting it without the information. And the second element is that the burden is showing that other ways of obtaining the information are not available or would not be effective. The appellant in this case has not met the burden as to either one of those elements. The damages sought in this case are solely for the survivor's mental pain and suffering. There's no claim for loss of net accumulations, loss of support and services. No economic damages were made here. So all of the evidence necessary to evaluate that mental pain and suffering claim is available to the defense in this case. We've talked about all the medical records to evaluate Mr. Rains' life expectancy. In addition to that, petitioner possesses all of the surviving daughter's mental health records to evaluate her mental pain and suffering damages. Mr. Rains' mental pain and suffering, he doesn't have any. He's deceased. So the federally protected, privileged substance abuse treatment records are simply not relevant to the issues in this case. And at the very least,
Well,
there's
they might be relevant, but I guess the question
Right.
is perhaps it's basically if this is a written case.
they're not necessary. They're not necessary in light of the expansive other information that's available that is that would support the issues in this case. Again, life expectancy and the survivor's mental pain and suffering. So, in fact, as the court points out, the petitioner has not even attempted to address the burden to compel the federally protected records. They've provided no explanation as to how these records are of such critical importance to the issues in this case. And they've not addressed, why the information can be obtained from other sources. They've also failed to follow the procedural requirements necessary to compel federally protected substance abuse treatment program information. That includes submitting a petition that uses a fictitious name that gives advance notice to the patient, which in this case would be the personal representative. Here, they had the records for 70 days before we were even notified of their existence, and we were notified in the form of their filing them under seal with the court, along with their motion for clarification. So they didn't provide us with advance notice before filing any papers to try to compel these records. So they violated the procedural requirements. They didn't address the substantive requirements.
Well, in this situation, if I understood the scenario correctly, these were documents they were trying to hold on to that were mistakenly given to them by the Social Security Administration.
Correct. They're outside the temporal limit of the authorization to the Social Security Administration. And it was a general authorization that was submitted, and these records, these sensitive records, can only be disclosed if there's a specific authorization saying, I authorize the Social Security Administration to disclose PAR records that encompass this treatment.
That wasn't there.
That wasn't there, not even close.
And he was, the decedent was receiving SSI, applied for SSI, was that
Correct.
correct?
SSI, he disability benefits that were purely based on physical impairments,
Right.
and not based at all on mental health issues. So it was a big surprise that the Social Security Administration even had these records, let alone that they produced them under the circumstances of a very finite authorization. So it clearly exceeded the scope of the authorization, and violated federal law. It's very clear as to what is necessary in order to produce these kinds of records. And the records themselves, the PAR records, each page of the records is stamped with a warning that redisclosure prohibited, cites to the federal regulatory scheme, and states that a general authorization isn't sufficient to disclose the information. So even without going to research the federal rules, it's pretty clear on its face what these records are, that they should have been produced and they shouldn't have been maintained, frankly, by petitioner's counsel for the lengthy period without advising us of their existence. And, that there were at least a subset of mental health records that the Social Security Administration produced that were reviewed by petitioner's counsel, and in fact, used information from that in the survivor's updated deposition, unbeknownst to us that they had these records, unbeknownst to us where these questions were coming from. And so, under these circumstances, it's difficult for me to believe that there's now a lack of understanding as to what these records contained. I mean, it's clear. It's clear what these records were. It's clear that the petitioner had no right to possess them at any time. It's clear that they've failed to meet the burden to both procedural and substantive to overcome the federal privilege, which is a very strong privilege. Courts across the nation have uniformly recognized it as a very strong privilege, including the 5th DCA here in Florida. So, and even setting the federal privilege aside, the court would have been well within its discretion to deny discovery of 7.5 to 8-year-old mental health records, substance abuse records. The authority cited by petitioner to that an in-camera review is appropriate and necessary relating to mental health care records. Well, that's necessary if you're going to compel them, but if you're going to protect them, there's no authority that's been cited, and I'm aware of none, that says the court needs to conduct an in-camera review before protecting the privilege.
Not in the case with Russell.
Right. So
Russell was a grant of a petition for cert to quash an order permitting access to the record.
correct, exactly. Russell was, the Shands Hospital was, the Zarkar was. In fact, all those cases say that the court should also impose reasonable temporal restrictions on the discovery of mental health records, including the Zarzar case. The court.
The court here had imposed a temporal restriction, and I think, they said 5 years. You go back 5 years on the records.
Well, right.
This stuff was beyond 5 years, so there's actually no need for the court to do an in-camera inspection of materials that were beyond the 5-year limitation.
Exactly. The effect of the most recent order was cutting off discovery for records that were over 7 years old. That's a reasonable temporal restriction, especially when the only argument made as to their potential relevance was as to his life expectancy at the time of his death in 2018. These records from 2010, 2011. So, so for all those reasons, it's our position that this appeal, has no teeth, has no merit. We did file a motion for 57-105 attorney's fees for having to respond to it, and we hope the court will consider that and also deny the petition with prejudice. If there's any other questions, I'm happy to resolve them. Otherwise, I can see the remainder of my time.
Thank you.
Thank you.
Very briefly. Yes, and hopefully I won't take that long. Very briefly, the irreparable harm lies in not knowing what's in the records or how they might affect the future of the case or the trial of the case or deliberations in the case. The order initially entered, we've been through 3 judges. They've made slightly conflicting rulings. In fact, in November of 2022, you'll note that respondents bring up in their brief that the court ordered that it would follow the Russell case and that it would conduct an in-camera inspection of any mental health records. And that can be found, I believe it's page 14 of their brief. The limitation that was put in place in March of 22, so 8 months or so before the November 22 hearing, when a different judge said I would look at the records and I'd look at them in camera, was 10 years as to CMS, Medicare, Medicaid, and then 5 years as to the Social Security file for whatever was in the file at the time. Again, the ruling does not exactly make sense why you would allow 10 years in the same order, allow 10 years on the one hand from one federal agency and then 5 years of whatever's on file with another agency. But that's what the court did. And in response to the authorization, a proper authorization from the plaintiff, the records were ultimately produced, and Your Honors read that there was a long time before any records were produced whatsoever. And then what they did, what the Social Security Administration did, was include whatever records were in their file, presumably from the 2013-2018 timeframe, but that would include presumably records that they had relied on. So I'm not sure that there. We talk about an inadvertent disclosure from SSA, but I'm not sure what they were supposed to do. If you're supposed to produce records from your file pertinent to this 5-year time frame, 2013 to 2018, and yet your decision making, your what's going on in that file relies on the full content of it, which in this case apparently included some records from 2011 or 2012. We don't think that's the issue, though. We think that the reasonable time frame would be 10 years. We believe that the trial court should be the gatekeeper of that and should have conducted an in-camera inspection. And the last thing I'll say, because I did have a chance to look back at the 42 U.S.C. 290, the portion of the code that deals with this, is that it does allow for redisclosure in accordance with HIPAA. So if it's for a HIPAA purpose and it's done in a manner that complies with HIPAA, and I believe that can be found at 42 U.S.C. 290 DD-2, that provided they're redisclosed in accordance with HIPAA, that is permissible. So I'm not sure entirely that there has been a violation of that aspect of the law either. If we look at, and again, that's a 2020 amendment, which I believe was in force at the time of this to that particular portion of the code. And I'll end my time and thank you all again.
Thank you both very much.
All rise.